No one lays down the law like Car and Key. This is the Law Report on SAFM.
And a very good evening to you from tonight's Law Report program. Well, as you know, once a month here on the Law Report, we run a legal clinic trying to answer a range of questions on a number of different topics. And tonight, it's again time to open the lines for you to ask that particular legal question that doesn't quite fit into the other topics we discuss here on the Law Report. And just a reminder, we're not doing property law or labour law because those all have their own precise programs. Well, I'm joined once again this evening by attorney Nicoline Skuman-Loh. She's the director of Skuman Law Inc., attorneys, conveyancers and notaries public and their practice here in Cape Town. Nicoline, good evening. Welcome back to the show.
Hi, thank you for having me as always.
Well, if you have any questions for us, you can call us now on 0892 10 20 10. And just a reminder that we do have an SMS line that's up and running. It's 40938. We do prefer to take the phone calls because then we can speak to you directly, and we have any questions, we can ask them of you. But if you aren't able to call us, you can SMS us on 40938. We do have just 3 emails to get through, so if you have a question, you can call in now, leave your name and number with my producer, and we'll call you back as soon as we're done with these 3 questions. And just once again, the number 0892 10 20 10 and the SMS line 40938. Right, Nicoline, we've got 3 emails. Let's just get started. The first one says, can a mother legally refuse her child to enroll and attend a creche? And this is obviously coming from the father and is obviously having a problem with the mother who's refusing to enroll this child in creche. And he, I'm assuming, wants the child to go to get the benefit of early childhood development. What are his recourses here?
Well, it would all depend on the arrangements made, presumably at divorce or separation. And if there's a court order directing how the care, how the child will be taken care of during the day, if there's detailed arrangements. Obviously, if there are detailed arrangements, those arrangements would obviously need to be updated or amended. And all of this would require some form of negotiation. So if the negotiations fail, then of course there could be recourse through a mediation process, and ultimately, if all of that fails, to approach court and to ask the court to direct what should happen in this case. At the end of the day, it's about what is best for the child, and I know these situations could become hairy between parents or ex-partners who are parents of children, and it would be better just to actually get to a place of negotiation and to make arrangements that are better for the child. So if that fails, the only recourse is court.
Right. Next one is, excuse me, it says it's an inquiry on a divorce matter. It's this listener says, living in Mpumalanga, has been married for more than 20 years, have 4 children. Our relationship has irretrievably broken down with no prospects of being revived, and we've finally taken a decision to file for divorce, which is in the process, and I have no regrets for doing that. I haven't moved out of the house, but we have been sleeping separately for close to 9 months now. My problem is that the process is taking too long, and I get provoked in the meantime. Even the kids no longer respect me. Their mother hurls heavy insults at me, calling me names, telling me that I'm lazy. I must confess that I lost employment in 2013 and currently do not work, but I'm still hopeful of getting another employment soon. I feel aggrieved because I started to provide for this woman when she was still a girlfriend. I assisted her to obtain her ID document when her family couldn't assist, helped her to get employment and a driver's license, and have been providing everything for my children while she became a spectator in her own game. What compounded the matter further is that I went to court to file for a protection order, and the magistrate refused to hear our matter. He argued that people often have quarrels in families and that does not necessitate a protection order, and suggested I move out of the house to avoid these. But I can't do that since I've got nowhere to go and I'm not working at the moment. So I want to know, what is my legal recourse in such instances, because I feel let down by the justice system, which seems to be biased towards women.
Oh, that's such a difficult situation. I can imagine. Very difficult situation, and particularly still living in the same residence must just compound the situation even more. So it's really unfortunate. Unfortunately, I must agree with the magistrate, and not because it's based on any gender bias. I would certainly hope that there are none, particularly in our courts. And unfortunately, from where we are sitting, it looks quite probable that there's no violence. It's an unfortunate situation, but it's certainly no element of violence that we can pick up on. And that's probably what the magistrate meant, is to say protection order is meant for a situation where there is violence or violence is imminent. Protection orders, if we can just take a step back, is all about a recourse in terms of domestic violence. So, and violence can obviously take a number of forms, but there needs to be a serious threat of harm, of bodily harm, or other serious types of harm. So it's probably in that context, I would presume, that the magistrate made that comment. So I don't think it's necessarily some form of bias that has revealed itself, to be quite honest with the listener. I think it's based on the fact that it's meant to
it's
prevent
verbal abuse, I think, that he's suffering, and that's not nice either, but it's not going to give him a protection order.
Yes, protection orders requirements are very specific, and there needs to be a very serious
physical
violence in most instances, or a threat of it, if it hasn't yet happened, so it's always a difficult situation. But of course, if it escalates, then of course do approach the court again. If it escalates and if it morphs into something more than a quarrel that is fairly unpleasant. Other than that, unfortunately, leaving the joint residence I would also imagine would be the best recourse.
He says it's financially not possible right now. But what worries me a lot here are the children, because it sounds, look, I'm not taking sides here, but it sounds almost as if the mother is putting the children against the father and turning them, it puts him in a very bad situation.
No, definitely, and unfortunately we see that happening in these type of matters quite often, and it's very unfortunate indeed. So it would be better, and most attorneys would actually recommend that their clients exit the residence. Perhaps look at, I know living by himself is not an option right now, but maybe a family member or a friend can extend that helping hand just to get over the formalities in the last stretch in finalizing the case. And once that has happened, of course, it wouldn't change the position drastically. If there needs to be a division of assets and there is no income for the listener, then I fail to see how his position is going to change when the case is finalized, and then he needs to move out of the joint residence. So it's a problem that needs consideration, if not for the immediate situation he finds himself in. He needs to think practically, what am I going to do when the matter is finalized? I would need to exit. Is what is going to happen in court going to change my financial position in such a way that I can do that? If not, what do I want? Maybe seek some legal advice through legal aid, and just know what your options are, and what would help to facilitate that moving out possibly earlier. So in short, I think he needs to go and seek some legal advice. And he says
the process of the divorce is taking too long, and these things do sometimes go on a bit.
Unfortunately, particularly if it goes through one of our lower specialized divorce courts, unfortunately they've got an influx of cases. So they're understaffed, they've got lots of matters to deal with, whilst the High Court, who also could deal with divorce matters, often has less to deal with. So you see cases being resolved fairly quickly through the High Court structure as opposed to the lower courts. So it unfortunately is nothing too out of the ordinary, I'm sorry to say, but having a legal representative could escalate it, and there is access to legal services through legal aid, through the legal clinics, or even through the law society in the area. So I think that's the first option, and just to find out what his rights are and in his particular circumstance, not just for moving out now, but also for leaving the joint residence once the matter is concluded.
Right, we're down to our last email now. If you'd like to call in, 0892 10 20 10, leave your name and number. We'll call you back as soon as we can, 0892 10 20 10. And if you'd like to drop us an SMS, the number is 40938. Right, Nicoline, another sad story. It says, I wish to ask for legal advice concerning my marriage, which seems to be on a rocky patch. My wife left last year in September. She has been very absent in her marriage obligation, as I languished under the impression that the whole withdrawal was due to the fact that her mother has been ill for some time. However, her mother passed away last year in June and thought that her absence would subside. I was under the impression that I have to be empathetic and not look for things like my conjugal rights, but persisted, supporting her all the way for taking care of her while still alive. I even took care for the chunk of funeral expenses, but has since come to my attention that I was shooting myself in the foot. The other thing that she keeps on demanding is money while at her home. Am I legally obliged to do that even though she's been absent for months? I'm also taking care of our child who is presently at tertiary education. Due to ill health and of course exacerbation caused by her, I had to resign from my teaching job. Though also unemployed but do some catering jobs, she wouldn't play a role to cater for family or even the child. Please advise me.
Oh goodness. Another
Two
very
sad stories, yes.
definitely very very unfortunate indeed. I think the listener probably knows, as I say in your heart of hearts, what needs to happen. I think it's clear that if one party is committed while the other is not, the writing's on the wall, as they say. So from the outside, it looks like a separation, a divorce would be the legal remedy. As to your duties to support your spouse, unfortunately, if the spouse is absent, whether physically absent or emotionally absent, the duty isn't affected. You still need to fulfill your duty of support to your spouse. So unfortunately, because of what is happening, you can't withhold or claim back any of the financial or other forms of support that has been given. Same goes, unfortunately, in regards to the child. The child is needs to be jointly maintained by both parents. And of course, if one parent is not in a financial position to do so, then your obligation ceases or is pinned until you are in a position to support again. A child going through tertiary education probably is no longer a minor, so there may also not be a duty of support there, but it depends on the arrangements that would be made during the separation and the divorce process. So to claim monies back right now doesn't seem plausible, based on the information we do have. Not supporting the child, unfortunately, there's a portion of support, a 50% portion of support that needs to be given by both parents. And if one parent is no longer in the position to give the support, then you can withdraw it. But I would think that the process needs to be started to make these arrangements, to formalize them, and that would be best probably through divorce action.
Rather sad, that. So
Definitely.
two rather sad stories. If you have any questions, 0892 10 2010, 0892 10 2010, and SMS line is 40938. Our first call is in Durban. Lucky, good evening.
Good evening, Karen and your guest, and how are you?
Very well, and you, Lucky?
Hey, I'm not well, Karen. I'm going to be short and sharp, but starting with throwing some numbers and statistics. You see, Karen, according to Statistics South Africa, here in South Africa, we've got this phenomenon of an absent father, and that has an impact in later in the life of a child. He may turn to be a criminal, gangster, and if it's a female, can be a prostitute. But what I want to talk about here is that the mother of my child is trying to build what I call a trump wall between my child and I. She doesn't want me to see her child, and it makes me feel very sad and bad because I feel alienated as the second parent of a child. So I wanted to know from your legal fund in the studio as to what is it that I have to do and where do I have to start.
Well, I think it could be good news, Lucky, because you do have rights when it comes to access to your child. Nicolene?
Yeah, I think South Africa, amongst many other countries, have taken a very proactive approach in terms of the rights of the father. which traditionally was seen as taking a back seat towards in terms of the rights, or in comparison to the rights that the mother would have to the children. So this is really good news in a case like yours. So you could approach the court for an order to regulate the access to the child, so visitation, and school holidays and those kind of things. And then, of course, you would also be obliged to contribute to the maintenance of the children, or to the child, or, in future, if there are more than one, then to the children. So courts can intervene and they could regulate this. But, of course, the courts prefer that one tries to resolve these matters amicably between you. You've said that there are some challenges in this relationship, so maybe that's not going to be your solution, but there are also mediation structures that you can follow through the Family Advocate's Office, and they can then also, through a counselling style, take into account the needs of the child and these other issues that the courts may not necessarily be able to handle in such a gentle way.
And this makes no difference whether you're married to the mother of the child or not.
No,
I'm not married.
That's what I'm saying. It makes no difference.
It's about the biological connection.
So when I go to the court, Karen, do I need a lawyer, or can I go on my own?
Well, you could go on your own. Any person regarding any matter could represent themselves in court, but I wouldn't recommend it, because at the end of the day, because you don't know always as a lay person, not an attorney knows
I
how
don't know
to.
the legal jargon.
Then you would end up having to go through a process that takes much, much longer, and could have been resolved much quicker and much easier. So I would recommend, if finances are an issue, to maybe approach legal aid or a legal clinic in your area, or even the Law Society for some pro bono assistance. But do get yourself an attorney to help you through the process. It will be quicker, and at the end of the day, it will be more effective, in my view.
Thank you very much, Karen, and I hope I'm speaking on behalf of millions of fathers out there, who don't know what to do.
Sadly, Lucky, we've had these sort of calls before, and I always say that it is good news for the fathers, because you have as many rights as the mother, as many rights as she has, much more so than a few years ago. About 10, 20 years ago, the fathers weren't really taken into account as much as they are now. So if you get yourself an attorney, as Nicolene said, if finances are an issue, the legal aid or one of the law clinics or even the Law Society will be able to help you, possibly with a pro bono attorney. You won't have to pay for that, and they'll be able to help you through this process. And Lucky, please do let us know how it goes. I'd really love to hear a good ending to the story.
Thank you very much, Karen, and enjoy the rest.
Thanks, Lucky. You too. Good night. Bye-bye.
Always good to hear.
Yeah, I know. It's always nice to know there is something you can do, because I think a lot of dads think that they don't, or the moms tell them you've got no right or something, especially when there's not a marriage. Like with Lucky, he's not married to the mother. He might have been told that there was nothing he could do because he's not married to the mother, and that's not true.
Yes, and it also breaks down the bias and the preconceived ideas that many fathers are absent by choice.
Well, that's what he was saying.
Great.
That's what he was saying.
Definitely
It's not.
great.
There are those out there, but there's a lot of guys like Lucky who actually want to be part of their children's lives, and I
that's
applaud
great.
them for that.
Definitely.
Right, the calls are lining up now. Let's stay in Durban. Myrna, good evening.
Good evening to you, Karen, and your guest, Nicolene. My question, I've got two questions. Shall I fire both?
Yes,
or?
go for it, Myrna.
Okay. Firstly, my mum recently passed away, and by provision of her will, I inherit the family home in total. I have a sibling that lives in the family home. First question, who does the estate pay for the maintenance and upkeep of the home in the interim while the estate is being wound up? Number two, I was looking after Mum. I wasn't working. Well, one, because of unemployment, and two, she felt that if I wasn't unemployed, all was well. I was taking care of her. She was in her 80s. Does the estate maintain me in the interim as well as the property? And at what stage do I have the right to give notice to vacate to my sibling that resides in the home?
Okay, I think that brings us to 3 questions.
Sorry.
So, no
fine.
problem. So let's start with the first one then. Firstly, it would depend on the exact contents of the will in terms of what you could, what expenses you could be able to claim back from the estate. And it would also depend on who the executor is and what their views are on paying for these expenses. So let's make this practical. If in the will doesn't preclude the executor from paying these expenses expressly, then it leaves the door open for a discretion. If the executor feels these expenses shouldn't be paid for by the estate, then they could perhaps advance your inheritance to you so that it could be paid from an advance. So there's a difference between paying the expenses on top of the paying the inheritance as opposed to it being advanced to you. So it would depend ultimately on what the will says, what the executor can or cannot do. I would imagine that particularly in terms of the maintenance of the property, the day-to-day stuff and the paying of the rates and those kind of expenses could very well legitimately form part of expenses borne by the estate, so that it wouldn't come out of your inheritance. Okay. I'm not sure, it's a grey area, and from the top of my head, thinking out loud, if I was the executor, I would probably not feel comfortable to pay for the time that you took care of your mum, and that you claim that through the estate. That I think it depends on the interpretation and the person concerned, but I think they you may definitely have a problem. But with the maintenance, it could potentially be claimed. To answer the question about giving notice to the sibling, the estate could give notice right now. If, for example, the sibling was causing damage to the property, or not taking care, or being careless, then as a step of preventing further damage to take place, that could happen.
Indeed, the situation.
Is that the situation? And that process would need to be driven by the executor. Or if the executor feels, and unfortunately this does happen, that it's too much of a conflict situation, let's rather wrap the estate up sooner rather than later, and then once that has happened and the property is yours, then you can do the necessary. So again, I think you need to sit down and speak to the person who's dealing with the estate and find out what they recommend and what they're willing to do and what not.
Oh, thank you very much indeed.
It's a pleasure. Good luck.
Thanks, Myrna.
Okay, love.
Thanks a lot. Bye-bye. Right, we've got a few SMSs just to get through quickly. One wants to know, are all legal practitioners going to have the right to appear in the High Court from February 2018? What will happen to the Bar of Advocates?
Well, it's definitely new for all of us. Speaking as a legal practitioner, the Legal Practice Act has obviously been signed into law and it's become effective. So a lot of things are going to change, and there are a lot of rumors. For example, the distinction between attorneys and advocates will no longer exist, which means any client can directly approach an advocate. Advocates will then have to run trust accounts like attorneys do, and all of that. So to my understanding, and I stand to be corrected, you would still require an admission to be able to appear in the High Court. That's how I understand it, but it's very new
for everybody.
It's very new for all of us, and we haven't really seen the practical implications of it. Our law society, locally and nationally, is busy transforming into the new statutory body that will be created by this legislation. So a lot of things are happening in our profession, and we are sort of watching this space. But to answer the question, no, there won't be any distinction between attorneys and advocates in the context that any client would be able to directly approach an advocate. You need not go through an attorney any longer, theoretically. But how the advocates, the bar council will regulate that and implement that and phase it in. I mean, this is something that is going to cause a drastic change. How the practical facilitation is going to happen, unfortunately, to the listener, we'll have to say, let's wait and see a little bit. But to my understanding, you'll still, for now, you'll still need admission to appear in the High Court as an attorney. So how this will roll out practically, I foresee that it will no longer be necessary in a couple of months' time.
And then we've got another one here. It says, my daughter from a previous marriage, obviously there's a divorce, is in tertiary. She's 19. When does my maintenance obligation end?
Usually when they come of age, unless they are financially dependent on you. So, give or take, many people have, there is case law also supporting the contention of 25, to say if the child is financially dependent on you but has reached the age of majority, which is 18, then you are still obligated to pay.
Till they finish studying normally.
Yeah, until so financially dependent is an interesting consideration in this context, because it's about more than just paying. It's about, where does the food come from? Do they live with you? And if the answer for all these things are yes, 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 then I think you'll have some trouble proving in a court that you no longer have the obligation to maintain.
Right, off to Polokwane. Zachariah, good evening.
Yeah, good evening.
Hello, how can we help you, Zachariah?
Yeah, please, I would like to know, from 2015, the way Home Affairs, they changed things like a private property, whether it's law or they are doing it illegally. I married a wife from 2010, and she been using the passport. She's coming from foreign country. Then from 2015, they bring some funny laws who I don't understand. I apply for her the relative visa. Then they say they reject it. Why did they reject it? They say, we don't have too much money in the bank. Then they give me 10 days to appeal. I appeal it within 10 days, but now it's going 2 years without anything. And the wife is not working, it's me who is working. Who are they meaning that he doesn't have too much money? If I don't have too much money, can't I stay with the wife? Or what do they want to tell me?
That doesn't sound right. I don't know much about the way that these visa things work. Do you?
And it's not my area of specialization. However, I can say that the appeals process through the department does sometimes take unreasonably long.
2 years.
And when it takes unreasonably long, I would say anything more than 6 months is unreasonably long. If you look at case law, you need to get yourself an attorney, and you need to take the department to court to force them to make a decision. And if the decision again is unfavorable or without proper reasoning, then that attorney can address that in a formal court process.
And would legal aid be something that could help him?
Definitely.
Zachariah, you need to go and speak to an attorney at legal aid or at one of the university law clinics, and they should be able to help you.
They need to take the department to court. They need to force them to make a decision, and if the decision is not clear or legal or set out properly, then that attorney needs to address that as well through a court process.
Yeah, because this law
can't
is
take
just
it long.
by this Kikaba thing.
It's too long now, Zachariah.
No, definitely. No, this. Unfortunately, you're not the only person who's in this position. Many other people are, and the only recourse you then have is to take the department to court. I know it's not pleasant, but that's
And then now
unfortunately.
in that process, the wife gave birth last year. Now they say I cannot make a birth certificate because it's me who is a citizen, not the wife.
Now
And
then
now
even
the child
more
is there
reason.
without any purpose.
Now you need to then treat this as a matter of urgency.
There's
and
actually
see
a
that
case
attorney.
going on about that at the moment.
I know.
With the local attorney who's dealing with that. Because he's not the only one. There's a number of cases where the mother is foreign and they're not being issued with birth certificates.
Yes, that's a major issue. Even more so, you need to get to an attorney sooner rather than later.
Okay, thank you.
Zachariah, can I maybe put you back to my producer? I'm going to just hold the line. Don't go anywhere because I want to actually get some information. Do you have an email address?
Yeah.
Okay, I'm going to ask you to leave your email address because I need to put you in touch with somebody that is dealing with this. I mean, that's actually taking this whole story to court at the moment. All right, so just hold the line, Zachariah. I'm going to put you back to him now, okay? Right, and while you're doing that, we'll go off back to Durban. But before we do that, if you want to call in, it's 0892 10 2010 and the SMS line 40938. And when you, just before we go to Andile in Durban, you mentioned that it was unfortunately these things are taking too long. We've had an SMS saying that we say unfortunately too much. And it's very depressing that we keep saying unfortunately. But a lot of these, sadly, and it was actually to do with those two cases we did, those two emails about the divorce. And it says, the people have had it says there's no hope or positiveness for any of those who've had the courage to request help or advice. But a lot of these times you have to say unfortunately.
Yeah, it's part of life, we suppose. It's really not always in our job description to have the answer in a positive way. In many cases, day to day for us at the office also, it pains us when there's no option other than to say, I'm sorry to tell you this, but this is your only option, or this is what is happening, and we can't change that.
Being realistic, we can't give people false hope on the show.
Unfortunately,
we can't say, well, yeah, that's great. Well, this is how we can fix this. A lot of the time, we can't do that. We've got to be realistic and honest. And if we have to say unfortunately, and it's not good news, it's just being honest. And I do apologize to the listener who was upset by that, but we're being honest and truthful. And, we're not giving people false hope. We're telling them this is basically the story. Where there is something good, like we did with a couple of the callers, like with Lucky, who was battling to get access to his child, we said, there's great news for you. You have something you can do. When there's something like that, we can do that.
No, definitely.
We can't just say that when it's not.
We can't, and we also can't. We need to meet expectations and manage expectations, so we can't be creating false hopes. It's unfortunately, ethically speaking, also we just can't do that, and it pains us when we can't give you more options and say A and B and C are your options, and these are the pros and cons of this one, and look for this and think about that, so that you have information. It's one of those things of life.
Right, let's go back to Durban. Andile, good evening.
Evening, ma'am. How are you?
I'm very well. How are you?
No, good, thanks. It's such a coincidence. I've been ordered by the maintenance court in Durban on Thursday to pay 3.5 towards the maintenance of my child. He's 9 years old. And I've been maintaining my child since his birth. With everything, medical aid and everything. But because I was unable to keep the slips because I was maintaining my child, and as a result, I was then ordered to pay 3.5. Now, my question is, what options do I have if I want to appeal it? And how much will it cost me to appeal? Because I've got other two kids that are also looking after me, and I can't have a situation where I'll maintain one child with 3.5 and others with less amount. And also the issues of affordability, So what is it that I should do?
Okay, well, first things first is I would recommend that you get yourself a legal representative. If finances are concerned, then you could approach legal aid or one of the legal clinics or the law society, like we've mentioned in the show throughout the evening. And they would be able to connect you to an attorney that could assist you at no charge. So first things first is you need to appoint an attorney. That attorney will then help you to it's not an appeal process, but it works very similar to an appeal process in the sense that you'll ask the court to reconsider or rescind is the proper technical term, the order that they made last Thursday. And then you'll give reasons, you'll go into the affordability and all of that. So you'll show your reasons for wanting to decrease the amount or wanting to do it very differently. sometimes what happens practically in these cases is that there's a concern on the part of the person paying the maintenance to the ex-partner or spouse, and that the ex-partner or spouse won't actually be spending the money on the children. So if there's a concern like that, and I'm not saying it is the case here, but if you are concerned, and I'm mentioning this because you've mentioned that you've been supporting your child with medical aid and all of that. So that tells me you've probably paid the provider directly, as opposed to giving the money to the ex-partner or ex-spouse. So if that is also a concern, it would also be good cause to vary the order that the court made last week. And of course, if you can illustrate why the finances are a concern, and the fact that you've got more than one child to support, and that you need to support equally and evenly, those are all factors the court will consider in reconsidering their decision, or rescinding their decision, or varying the order that was made.
So, are there any attorneys that you may recommend around Durban? Because I am really frustrated and I don't know what to do. I'm not a legal expert, and this thing caught me off guard. When you have been maintaining your child since he was born, and there is an evidence, that this child has been in my medical aid ever since he was born, including the mother. There is an evidence also from the school that I'm the payer, but now in court I'm being told that I was only returned there because I'm the father. And my question is, how can an irresponsible father be returned? As a payer at school, those are issues. And I was ended up, being sentenced to pay 3.5, and I could feel that the magistrate was more personal than looking into the details, because she was not even willing to argue on the issues of the breakdown as what is it that has made her to arrive into that 3.5, and in her order, she said that on top of this 3.5, I must continue paying for the medical aid.
Oh goodness, then that escalates that amount quite drastically. Now,
also, ma'am, I've submitted in court that my bank deductions are 13,000 rand, and then now I'm left with 7,800 rand. Without having buy groceries and petrol and stuff like that, without having maintaining other kids, which means that if I'm subtracting this 3.5 from this 7,000 rand, I'm left with 3.5. Now, how am I going to live with 3.5 with the other three kids? So
no, you need to.
Kind of issues that yes, sir?
You need to urgently get yourself an attorney. So unfortunately, we can't recommend anyone particularly, but if you phone the Law Society in the area, they will be able to tell you who specializes in maintenance matters, and that's what you need to ask for, an attorney that specializes in child maintenance matters.
Okay. Estimately, how much do they cost? Estimately?
Well, the Law Society, if you speak to them and tell them your situation, you could possibly get them to refer you to an attorney who may do it pro bono, which means it doesn't cost anything. But you need to speak to the Law Society of KwaZulu-Natal, KwaZulu Law Society of KwaZulu-Natal, and speak to them, and they'll be able to direct you.
Thank you very much. And
Good
thank
luck.
you for this kind of a program. It will assist us because we can't afford to allow our kids to be street kids,
Absolutely.
Absolutely.
Okay, thank you very
Thanks, Andile. Good night to you. Bye-bye. Right, just quicker. Somebody suggested here, they say here, from Shepo, says, may I suggest a cheaper and easier way for the fathers to get their cases addressed? He suggests that they approach the Commission for Gender Equality. They're a statutory body to support society on gender issues and rights, and all provinces have officers to assist. Would they be able to help you if you're a dad? The Office of Gender Equality and...
It's one of our Section 9 institutions. Yes, they are a statutory body dealing with gender-based issues. So they would take on sort of class actions, if I could term it that way, if there's an issue that many people are experiencing. So maybe, for example, that the fathers do not have access to the system, or there are certain portions practically within the system deterring fathers to approach. If that is statistically proven, in other words, to affect a number of people, then yes, you could actually approach them. They would investigate how many people are affected, and then they would lobby on your behalf, or make policy changes and lobby for policy changes in a range of different ways. But of course, because they need to represent a collective, they need the numbers, and it does take some time. So if you're looking for a quick solution, that could be a long-term solution, but not necessarily a quick one. But definitely something to consider. It's a very good point made, actually.
We've got another one just saying to our previous caller, go to Legal Aid for help. We have mentioned all along at Legal Aid, the law clinics at universities, the Law Society in your area, any one of those three, or all three, try them all. They will be able to help you. So Legal Aid, thank you to the listener who sent that in. Yes, it's definitely one of those places that we do suggest that people go for help. And then before we take the next call, just very quickly, another SMS says, my daughter's ex-husband is now openly gay. Does he have a right to expose my minor grandchildren who are 5 and 8 to his gay partners and culture when he takes them to his house?
It's a difficult situation, and my heart goes out to the family. It's any relationship that breaks down for whatever reason is painful, particularly for the children. We appreciate that. However, the ex-spouse also has a right to their beliefs, to their lifestyles,
sexual orientation,
all of that. It's a constitutional right, similar to our constitutional rights to look for the best interests of the child, for the children to enjoy equal and fair treatment, and all these global constitutional rights that we all are entitled to. So unfortunately, no, in short, is the answer.
So, unless, of course, there is something that you're unhappy about, that the children are being exposed to something that you wouldn't expose them to in everyday sort of normal life, then maybe you have got a point. Maybe you speak to the partner then. That's your first recourse, is to speak and say, look, I'm really not happy with what's going on, but try that mediation, that negotiation between the two of you first.
I also think one should not forget that in many households, when a relationship breaks down for whatever reason, I want to make that very clear, it doesn't really matter why.
No, it doesn't matter what, yeah.
And in a heterosexual setting, if that ex-partner were to have multiple boyfriends or girlfriends,
True.
It's a similar exposure, in my humble opinion, than it would be in this case. And that's why we need to go back and say, if it wasn't because you possibly disagree with the lifestyle, if it was that similar situation, would you still feel equally aggrieved? And maybe measure it to that, because maybe it's more familiar to measure it to that. And if you still feel aggrieved that some line is being crossed, some other moral boundary, and you are concerned over the well-being of the children, and it's not based on that lifestyle or sexual orientation or choice that has been made,
but it's a general morality issue,
then yes, then you need to intervene and try the mediation route first. But if it's more serious, then of course you need to take more serious recourse. But I would say just for a moment, park one's own judgment and maybe just look at it from that other angle to say, if it was another setting and this also happened, would you feel the same way? And honestly ask that question before taking any further decisions.
And yes, the thing is, you've also got to think of the children as well, because you don't want to portray their father, because it is after all still their father. And you want them to have a good relationship with their dad.
Yes, of course.
Regardless of what has gone. I know everybody, it's sad, and it's a relationship that's broken down. But the children are what's important here.
Yes, and I think we often forget that because of our own opinions or beliefs about certain things. And maybe let's just take a step back and think about what is really, really, truly good for the kids.
Right, well, we're chatting this evening at our law clinic. Any calls you might have, if you want to still get through to us on 0892 10 20 10. We are getting close to the end of the show, though, but you can still try. We'll be back shortly.
No one lays down the law like Car and Key. This is the Law Report on SAFM.
Right, off to Port Elizabeth now. Peter, good evening.
Hi, good evening. I hope you guys are well, and thanks
Thank
for
you.
taking my call.
Pleasure. How can we help you, Peter?
All right. I got divorced in 2013, and I've got 2 daughters. My wife left, and she went to another partner. I looked after my children until 2016. I didn't ask her for a cent. She didn't make contact with my children at all. But my youngest child was in a serious car accident. My business got into a bit of trouble the end of last year. 2 years, 2015. It became into a bit of trouble. And she said, listen, she will take the children suddenly. I don't know why. I didn't know at that time. Then she found out about the road accident fund, which I don't have a problem because I signed a thing that I don't want anything from her money because it's for her to get her treatments and everything because her arm is seriously damaged. And she took the children. She said, all right, I must sign papers. So we went to court, and I said, I'll pay maintenance at the moment. It's not a problem. And she said, well, once I'm back on my feet, then I can have the children back because my children has got hearing aid problems, both of them, very seriously. They moved to Limpopo, and I'm back on my feet and everything, and I'm still paying maintenance. I'm paying all the flights every time down to me. But now this last semester that just passed, the children failed horribly, like 14%. I phoned the school and I said, listen, do you know my children has got hearing disabilities? And she said, no, they don't know because they're not wearing hearing aids. Now, I purchased 2 sets of hearing aids for both of them of 120,000 and 80,000. And apparently those things are gone. Now, I can WhatsApp my children, obviously, because I can't speak to them. So I WhatsApp them, and they said, I asked them, where's the hearing aids? And they said, no, they've got it, but the mom doesn't want to fix it because you have to put them in for repairs now and then and stuff like that. Now, I pay 6,000 Rand per child per month. And I asked her, what are you going to do with the children because they can't fit into that school? I went to a lawyer in Pretoria. I flew down there. We went to Rustenburg because that is where she took me to court, the maintenance course, because she wanted more maintenance, and she wanted the children for her to be the primary caregiver because I was the primary. But because I ran into a bit of financial difficulty, I was thinking about the children and signing them over to her for the period that I cannot sustain it anymore. But now, this holiday, I purchased tickets again for them to come visit me, and she just never pitched up with them at the airport. Yeah, and I'm a bit confused. What can I do? Can I help my children? Because the one's 16 already. She failed last year when she was with her mom. But somehow her mom didn't hand in a report, and she moved up to the next grade in any case. And then the school doesn't even know that she did not make it last year. So,
Peter, do you still have primary custody of the children, or did you just sign them over to her for a short period, or what was the story?
Yeah, when we got divorced in 2013, she left. She didn't even say goodbye to my kids, and she never made contact with them until she found out about the road accident fund. Because she didn't even come to the hospital when my child was in hospital. Nothing went. And then she found out about the road accident, and then she said, "Listen, my mom and them are quite wealthy. I will look after them. But you need to sign this because otherwise you can take them back at any time." And my mom and them don't want that. I said, all right, that's fine. For the children's sake, just make sure they go into a school where they can be proper taken care of. Because with a disability, you need to take care of that.
Okay, so we're running out of time here, Peter, so I want to get Nicoline. I want to just answer you before we run out of time. What can Peter do?
Well, I would say first things first, you need to get in touch with that attorney, either the same one you used in Pretoria, or someone closer by, and I would make a case to become the primary caregiver again, and to use as evidence to substantiate that while they were living with you, the school went well and the marks were looking good and all of that, and now that's not the case. You know, in addition to maybe if the children have themselves, if they've got complaints of neglect or of rejection or anything like that, then of course, unfortunately, you'll have to go there and they'll have to speak up and motivate why they would rather want to live with you, so that you can basically overturn that paper that you signed back then. And if it's their choice to live with you, then of course, if the children, generally speaking, are over the age of 12, then the court actually asks them, who would you like to live with? And if they want to.
The youngest one in December cried and she didn't want to go back. But because the maintenance, we went to court and it was signed over, I was scared I'm going to get into trouble because what am I supposed to do?
No, it's a difficult situation, but I would recommend that you actually get that paperwork turned over, and the only way you can do that, practically speaking, is to approach court and to show cause that it would be better for them if they come live with you again.
Do I have to go back to Rustenburg, or what can I do?
Well, the jurisdiction of the court works. Usually, the easiest way to determine jurisdiction is where the children are currently situated. So if it's over there, then you need to go back there. It's unfortunate. Otherwise, you don't want to run. I know it's difficult, but you don't want to run into a technicality. You want it and expensive, unfortunately.
Yeah.
Peter, good luck.
The thing is, I've got an eye problem, so I've got a driver driving me up and down, so that's fine. But for me to leave my business as well and to go there up and down, it's damn difficult, and that's the problem.
It's probably the only thing you, unfortunately, here I go again, going to be able to do, Peter. I'm so sorry.
No, okay,
but
cool.
good luck
No
with
problem.
that. Thanks
A
you.
lot.
Good night. Bye-bye. I want to squeeze in one more call, but before we do that, Tsepo, who actually SMS'd us earlier about the, about the GCE, Commission for Gender Equality, says, I am actually provincial manager in Kimberley in the Northern Cape. The GCE, the Gender Commission for Gender Equality, I'll get that right in a minute, investigates individual matters as well, be it maintenance, access rights, legal clinics, awareness campaigns, and mediation matters, etc. We do this above the class action. So they do individual cases as well as the class action. So that's amazing. So he says the fathers could even go to the website, which is cge.co.za. So cge.co.za. Go and have a look there. That's great. We've all learned something now. Seppo, thank you so much for letting us know about that. And so dads out there, if you're wanting some more information, go and have a look at the website, cge.co.za, and there's another avenue for you. Now there's 4 things. That's another one. That's fantastic.
Hopefully some more change can be facilitated through speaking up. So don't be deterred. We've learned a valuable lesson today. It's not just about numbers. It can go down to the individual level. And that's absolutely
great news.
Fantastic.
Thank you so much for letting us know. Right, we've got about 2 minutes. Jackie, if you can be very quick in Port Elizabeth. Good evening.
Good evening. Yeah, I'll be quick. I'm phoning on behalf of my sister. She's a social grant recipient, and she went into a hire purchase contract with Ellen, I think about 2013. When the stuff arrived, she wasn't happy with it, and after numerous calls, and they just ignored her because she wanted to take it back, and she stopped paying them. And since 2014, so she told me this weekend, they've been deducting 400 rand a month from the social grant until last week. What we need to know is what can we do going forward.
They need to get hold of SASA, basically, because those things weren't they deemed illegal? You can't take deductions off the grant. What was that? Yes.
If memory serves me correctly, and I'm not aware of any recent change to the law. In fact, I think the status quo prevails. You can't make any deductions. That's
against the law.
Yes. So I would strongly recommend that she seeks legal advice on a pro bono basis if needs be, if money's of concern.
But you need to, first of all, get hold of the SASA office in Port Elizabeth.
Yes.
Jackie, get hold of the SASA office in Port Elizabeth. Tell them what's happening, because I know there were a number of cases where people were having this happen to them, and you've got to report it to SASA, because they've got to actually investigate this.
She's been to SASA. She even contacted a state lawyer. She's been to Africa Bank, and she just walked into a brick wall all over.
Then unfortunately, if she's exhausted all these other avenues, then your only recourse is an attorney. and taking them to court.
Jackie, I'm sorry, Jackie, we've literally got 45 seconds to go. We've got your number. Next time we do a law clinic, we'll see if we can't find out more information and get hold of you again. But I have to say thank you once again to Nicoline Skuman-Low, who joined us this evening. She's a director of Skuman Law Inc., attorneys, conveyancers and notaries public, practicing here in Cape Town. And she's been my guest on tonight's edition of The Law Report. And we'll be doing another law clinic on Monday, the 8th of May. Nicoline, thank you so much for joining us once again.
Thank you for having me.
In next week's program, we'll be looking at laws surrounding children with disabilities, finding out more about employing foreigners, understanding the rules and regulations regarding probationary periods, and talking about the problem of fake court orders. That's the Law Report next Monday, the 17th of April.